Hello, welcome to our July TSCA 3030 program, talking about TSCA preemption of state chemical control laws and regulations under the Biden EPA. My name is Greg Clark. I'm a partner in the Washington, D.C. office of Keller and Heckman. I work on a variety of environmental statutes and regulations, and in particular TSCA. Next slide, please. And I'm joined today by Eric Goding, who's also a partner in our environmental group. Eric also works on litigation matters for us in our litigation group. Next slide, please. So today's topic is preemption. A quick overview in terms of what preemption is. So preemption relates to the supremacy clause of the Constitution, which says that federal law, in essence, trumps state and local laws. There are two types of preemption. There's express preemption, which is what we're talking about today, where a federal statute explicitly states that it preempts state law. And then there's implied preemption, which relates to instances where there's a conflict between state and federal law. But there's not specific provision in that federal law indicating preemption. Next slide, please. So we have a good bit of ground to cover on the overall impact and procedures for preemption. So we're going to move fairly quickly through the background. But preemption is in section 18 of TSCA. It's actually a quite detailed section of TSCA, and one that was amended significantly when the Lautenberg Act was passed, preemption being a key bargaining point in terms of reaching a bipartisan consensus on amending TSCA. So there are five key types of preemption under TSCA. We'll be talking today on section 6, but there are other areas as well noted on the slide. So for example, there's information development preemption, and that's related to sections 4, 5, and 6 of TSCA, preempting state information development requirements that is duplicative to, for example, a section 4 test order under TSCA. Under section 6, you have safety finding preemption, risk management preemption, and pause preemption. And then there's also notification preemption, which relates to section 5, significant new use rules. Next slide, please. So we are talking about and focusing on section 6 today, because that's really where a lot of the action is right now under TSCA. EPA is performing risk evaluations for 20 high priority substances, as well as a handful of manufacturer requested risk evaluations. There are also the first 10 chemical substances where EPA completed risk evaluations, but in many cases, the Biden EPA is taking another look at those risk evaluations. They're also working through risk management rules for those first 10 substances. So we'll begin with pause preemption. Pause preemption begins when EPA publishes the scope document for a risk evaluation for a high priority chemical. It states that no state or political subdivision of a state, meaning a city or other locality, can establish or continue to enforce a prohibition or restriction on a chemical substance. The preemption applies to those activities that are covered by the scope of the risk evaluation. Timing, the pause preemption remains in effect from the date of that scope document being released to either when the final risk evaluation is published by EPA or when the statutory deadline for EPA to complete the risk evaluation passes. And it's whichever comes sooner. So either that final risk evaluation is complete or 3.5 years from the beginning of the risk evaluation from the prioritization passes. Now, preemption becomes permanent. Pause preemption moves into permanent preemption when EPA determines that a substance or use of the substance presents no unreasonable risk, or if EPA completes a risk management rule. And we'll talk about those types in the following slides. So safety finding preemption. This prevents states from prohibiting or otherwise restricting the manufacture, processing, distribution, and commerce or use of a chemical substance when EPA makes a finding as part of the risk evaluation that chemical substance or that use presents no unreasonable risk. And the scope of that preemption follows the scope of either what EPA did for the risk evaluation, if EPA makes that finding for the entire chemical substance, or for that particular use that EPA found doesn't present an unreasonable risk. Risk management preemption. So states cannot prohibit or otherwise restrict manufacture, processing, distribution, and commerce and use. So similar language again to the last. When EPA issues a Section 6 risk management rule. So this is the regulation that follows a risk evaluation when EPA determines that there is an unreasonable risk. The scope of the preemption is consistent with the scope of the risk evaluation and the action that EPA takes under Section 6A to regulate that risk. Risk management preemption and safety finding preemption are important. We mentioned earlier for pause preemption that's limited to high priority substances. So when you have a manufacturer requested risk evaluation, it's safety finding preemption and risk management preemption that are going to come into play. So I think it's always helpful to illustrate this because it is fairly complicated. So if you're thinking about Section 6 preemption in terms of a timeline, so these red points are where the state is preempted, and these blue points are where the state is free to regulate or enforce restrictions. So we have the first red block is the scope of the risk evaluation, triggering pause preemption. We have a no unreasonable risk finding, which would trigger that safety finding preemption. And then finally on the right, you see risk management effective date. That's when risk management preemption comes into play. So I won't go through this in too much detail, but there are some statutory exceptions and exclusions from preemption. Certain state actions are grandfathered in. Rules that come under laws that were enacted prior to September of 2003, as well as chemical specific rules that were issued prior to April 2016. Distinct information laws at the state level also are not preempted, nor are laws that protect air or water, manage waste, or where the state is acting in a delegation of federal law or authority. State tort law is not preempted either. There are waivers that may apply. So there are both discretionary waivers and required waivers. Now the state is required to submit the waiver request to EPA, but in the case of a required waiver, it's mandatory for EPA to grant it, and if EPA fails to act, that waiver will still come into play. That's a required waiver from pause preemption in certain circumstances where a state can act during pause preemption if that action occurs after prioritization but before the scope of the risk evaluation is published. Or if EPA makes a determination that there's no undue burden on interstate commerce, no violation of federal law will come about as a result of the state law, and the state action is based on peer-reviewed science. Very similarly are the criteria for a discretionary waiver. There must be a compelling condition, no undue burden on interstate commerce. There won't be a violation of federal law as a result of compliance or action in accordance with the state rule. And the state action has to be based on best available science and the weight of the scientific evidence. So whereas required waivers are related strictly to pause preemption, discretionary waivers might apply to any of the other types of preemption. So this is the focus for us today. So there are a number of key changes that the Biden administration, the Biden EPA are carrying out policy-wise under TSCA. I'm sure you've heard these in our previous TSCA 30 for 30s or in the trade press, but they're pretty critical and they do impact preemption in a very significant way, a number of significant ways. So first, the whole chemical risk determination, specifically that EPA is not going to make individual condition of use findings of unreasonable risk or no unreasonable risk. EPA is de-emphasizing Section 9, the regulatory nexus approach, paying less deference to other EPA programs like the Clean Air Act or the Clean Water Act that might adequately regulate exposure. And we also know that EPA is planning to miss deadlines. We've heard from EPA that they do not intend to complete the risk evaluations within the 3 to 3.5 years provided by the statute due to a lack of resources. So taking those policy changes, they're going to impact a variety of the different preemption provisions. So under pause preemption, as we talked about earlier, the scope of the risk evaluation determines the scope of pause preemption. So to the extent that EPA is conducting a broader risk evaluation, that means you're going to have broader pause preemption. Now, I will note that there are those exclusions and exceptions from preemption, particularly as it relates to state laws that protect air or water. So while the scope might be broader, it wouldn't extend as far as that. We know that the risk evaluations are going to be late. So that means effectively that we're going to have the maximum period of pause preemption. It's going to go that full 3.5 years for the statutory deadline. But it also means that they're going to end early. They're going to end before EPA has completed the risk evaluation. So pause preemption will end before that point. And as EPA conducts risk evaluations more slowly because they're not completing the ongoing risk evaluations on time, we're going to see over time fewer chemicals designated high priority, which means that fewer chemicals will be subject to pause preemption. For safety finding preemption, we know that EPA is redoing many of the first 10 risk evaluations. As they are going through, they're also revoking the 6I1 orders where EPA made findings of no unreasonable risk. So that means that safety finding preemption won't apply there. To the extent that EPA is also conducting its risk evaluations on the chemical substance as a whole and not making findings on individual conditions of use, it means that going forward, there's not going to be safety finding preemption because EPA won't be making those 6I1 findings. Finally, risk management preemption. So again, the broader scope of risk evaluation means that you're going to have broader risk management preemption because, again, the risk management preemption provision is tied to the scope of the risk evaluation. And as I mentioned, to the extent that EPA has late risk evaluations, that means that that gap, those blue periods that we showed on our illustration between pause and risk management preemption as EPA completes the risk evaluation and then begins work on the risk management rule, there's going to be a larger gap between that time until EPA ultimately passes or promulgates a risk management rule, and the effective date of that risk management rule triggers risk management preemption. So just breaking down a little more detail on those safety finding preemption. So for a variety of these first 10 risk evaluations, there were conditions of use that were identified as not presenting an unreasonable risk. So those preempt any state action there. But we know that EPA is going to be revoking these. They have already revoked, in the case of HBCD, those findings for 6 conditions of use, and for 4 other substances, methylene chloride, NMP, PCE, and pigment violet 29. EPA has issued proposed rules to update the risk evaluations and revoke those 6I1 findings. So it's at least for those, for methylene chloride, for NMP, and for PCE, I believe all of those comment periods are ongoing. So if you have a condition of use that was found not to present an unreasonable risk, then now is the time to submit comments to try to protect that finding. So a few examples of state laws that we wanted to talk about to just further ground the discussion. So in New York, there is SB 4630, which was enacted at the end of last year. So it actually follows, it's after the date of the risk evaluation scope for TBBPA. And so actually this substance is subject to pause preemption, yet New York proceeded to pass this law which would ban TBBPA and other halogenated flame retardants in mattresses, upholstered furniture, consumer electronic displays, TVs, and monitors. And that would go into effect at the beginning of 2024. So in fact, it would go into effect during the pause preemption period. We also have the Environmental Conservation Law, Articles 35 and 37. Now that limits 1,4-dioxane in household cleansing products and personal care products to trace concentrations. And that trace concentration threshold goes down over time, with the first threshold going into play at the end of this year. And for 1,4-dioxane, that's a substance where EPA has completed the risk evaluation and found no unreasonable risk for uses that are in fact covered by this New York law. Consumer use in surface cleaners, dish soap, dishwasher detergent, laundry detergent. For all of those uses, EPA found no unreasonable risk, so safety finding preemption would apply. In Washington, there's the Safer Products for Washington program. So this is based on a statute that was passed in 2019, but because that was not grandfathered, doesn't fit into the grandfathering date, right? That means that the regulations that come under that statute are still subject to preemption. Washington is reviewing a variety of substances which are flame retardants, substances that are phthalates in certain products. 6 of these substances are subject to pause preemption because they're part of the 20 high priority substances. HBCD is one of the first 10, and it was subject to safety finding preemption until just a couple weeks ago, EPA finalized a new risk evaluation revoking those safety findings. Now, for this program, for the Safer Products for Washington program, the regulations haven't been promulgated yet, but there's likely restrictions on the use of these substances in a variety of products, yet pause preemption would still apply. So it'll be interesting to see when they complete those, if they in fact tailor it all to try to avoid the pause preemption. So now I'll turn it to Eric on the topic of, well, we've got preemption in some form that applies, and we have a state law. So what can a company do to try to enforce the preemption?
Well, thanks, Greg, and thanks to everybody for joining us today. So what can a company do? Well, once a state or local government does take some sort of action, and assuming one of the exceptions Greg discussed does not clearly apply, companies have several options to invoke preemption depending on the circumstances. First, a company could bring a suit in federal court under what we call a facial challenge to the state or local action. And this is where you seek pre-enforcement review of the statute or regulation and ask the court to prevent its enforcement going forward. And so the company is not waiting for the statute or regulation to be specifically enforced against it. Instead, it's asking the court to essentially enjoin the state or local government and to prevent the statutes or regulations enforcement, against anybody going forward. And so this case would likely be filed in federal district court. That's the trial level, so not an appeals court where we sometimes go. It would be in the federal district court. The court's jurisdiction would simply be under the federal question statute, because here not only do we have a federal question because there's a constitutional issue, we also have a statutory question because it involves TSCA's preemption, express preemption clause. And just as an aside, because the 11th Amendment, for the lawyers on the call, likely bars you from suing a state or a state instrumentality in federal court, like an agency, you will likely have to sue those state or local officials who would be responsible for enforcing the statute or the regulations. So, for example, you would sue in the name of, or you would name the commissioner of the state version of EPA. That's who you would sue. Second, a company could defend on preemption grounds in what we call an as-applied challenge when the state or local government tries to specifically enforce a state statute or regulation or order against the company. And here it's likely that you will have to remain in state court because removing to federal court under the federal removal statute is very difficult on preemption grounds. Essentially, unless the statute completely preempts the field or subject matter, which TSCA does not, is exemplified by all the exemptions Greg went through, successful removal is going to be unlikely. So you're going to be stuck in state court. And so this raises an interesting strategic question. Does a company or an industry wait until enforcement actions begin to challenge on preemption grounds when you may be stuck in state court, or do you want to instead take the initiative and file a facial challenge in federal court so that you might be in a little more of a friendly venue? So that's something to think about. Third, at least with regard to state regulations, so not statutes that are adopted by legislatures, but state regulations that are adopted by agencies and perhaps some ordinances adopted by local governments, there are a few indirect ways to challenge those actions on the basis of federal preemption, and it's going to depend on kind of the law in each state. But the first potential option is through what we call state mini administrative procedure acts or similar statutes. And some of you on the call may be familiar with the Federal Administrative Procedure Act, or what we call the EPA. You may have heard of that. The EPA governs all aspects of rulemaking and how federal agencies formulate and propose and adopt regulations. And one aspect of this process is requiring agencies to go through what is called notice and comment period, where it publishes a proposed regulation so that stakeholders like you guys and other interested parties can submit comments. And then the federal agency must then review those comments and respond to them, explaining how it took the comments into account. It has to explain how those comments impacted its final decision, et cetera. So many states have a similar statute that requires some form of notice and public comment, and a requirement that the state agency respond to those comments when finalizing a regulation. So this presents an opportunity for companies and industry to raise the federal preemption issue and note that the proposed action is potentially preempted by TSCA. And under some state mini APAs, if the agency ignores those comments, there may be an option to bring in a lawsuit, probably in state court, to get a declaratory judgment setting aside that regulation as not complying with rulemaking procedures. And so while this is not guaranteed to give a company permanent relief, as the agency might have a chance to fix the problem and re-promulgate the regulation, it will at a minimum force that state agency to address the preemption issue and perhaps come to the conclusion that it cannot act, that indeed preemption does apply. And if that's the case, you have now essentially won on preemption grounds. So pay attention to the applicable state mini APAs. A second potential option is relying on a state statute that actually gives the state agency authority to adopt a particular regulation. So it may be that the underlying statute requires the state agency to consider whether a proposed regulation will potentially conflict with a federal regulation, and if so, that it should not be promulgated in the first instance. So an example is California's green chemistry statute and its implementing regulations called the Safer Consumer Product Regulations. And as we all know, California's green chemistry program authorizes the California Department of Toxic Substances Control, or DTSC, to designate chemicals that are used in certain products and force companies to either abandon their use or to find a safer alternative. And so there are various provisions in both the statute and the regulations that direct DTSC to consider potential preemption problems as it goes through the process of designating and regulating priority products. So granted, DTSC does have a lot of discretion to decide whether there is a potential preemption issue. Now, ultimately, a court will decide that, but DTSC, at least in the initial instance, has some discretion. But again, at a minimum, if DTSC fails to adequately consider the matter, there may be an opportunity to challenge in court the resulting regulation as procedurally unlawful and at least get it temporarily, if not permanently, set aside. So pay attention to the underlying statute granting the rulemaking authority as well. So those are four things to think about and four options, depending on your circumstances, on kind of how to inject preemption into the debate and have a court or perhaps the administrative agency agree with you and get something set aside. So that concludes my comments.
So Eric, if the statute at issue or the regulation at issue by the state covers a class of substances, for example, halogenated flame retardants, as the New York statute does, and that includes a substance for which preemption applies, as is the case here, does that change the strategy at all in terms of whether you should pursue a facial challenge or wait until state enforcement?
So I think it does, because it brings up a standing issue. So we all probably kind of have an idea of what standing is. Standing means you have to be someone who's kind of been wrong to bring a lawsuit. You can't sue on behalf of someone else. And so if you have, let's say, 10 chemicals that have been banned by a state under a certain law, and a company brings a lawsuit in federal court, it does that facial challenge, the first option. It may only have standing to challenge that statute as to the chemicals it makes. So let's say it only makes one of the 10. And so that would be an issue that the court and the parties would have to resolve. So one way to deal with that would be to have a trade association whose members collectively make all 10 chemicals. And so their trade associations do have standing to bring these types of lawsuits. And under certain circumstances. So a trade association could bring that lawsuit and cover the entire, and have standing to challenge the entire statute, all 10 bans, so to speak. So you would want to think about how to do that. And obviously going to federal court under a facial challenge is going to be more effective and efficient than waiting for the enforcement, because the enforcement presumably would only be, against, let's say, one company and one chemical. And you want to maybe perhaps challenge them all. So the facial challenge via trade association might be the way to go.
Great. And what, Eric, then you think would be the role of EPA? So preemption is, if you think about it as a base matter, it's the federal government, exercising essentially authority over the states, or trumping the authority of the states. Now, if EPA were to send a letter to the state indicating that EPA believes the state law regulation is preempted and the state needs to submit a waiver request, if EPA were to do that, how would a court view EPA taking that position publicly?
I think it would be persuasive. I think it would come up, obviously in an enforcement action in state court, where you're defending on the preemption issue, and that's your defense. And your argument's going to be, hey, look, EPA agrees that preemption applies here because they sent a letter to the agency saying you need to get a waiver. Is that going to be dispositive in that case? No, probably not, but it's going to be persuasive. And courts do give deference to agencies for reasonable positions that they take, and presumably it would be reasonable for EPA to do that. I think the bigger challenge might be getting EPA to write that letter. This firm has had agencies write letters and kind of say, we think X, or, if we were to apply, the statute, here's how we would do it. In this instance, it can be difficult to get an agency to do that. But if they sent that letter, I think that could be persuasive to a state judge.
Yes, and I think, that's great points. And I think that, overall, until EPA takes some action here, and, frankly, the statute was designed, and if you look at the legislative history, the intention was for states to participate in the EPA risk evaluation process rather than for them to work in parallel and be duplicative. But also until we see some challenges from industry, there's going to remain this kind of void where states are going to continue to take action, even though preemption would apply, as long as that authority and power hasn't been asserted, and until they're challenged. It seems to me that we'll continue to see these types of state actions like we talked about in New York and in Washington. Now, we're just over a minute past our time, but I did want to answer a couple questions that came in. So a couple questions related to PFAS. So in terms of the preemption provisions, so we talked about Section 6 for, there are also some PFAS provisions that might come into play if you had a SNR, but by and large, the preemption would apply once EPA, in fact, begins a risk evaluation for a PFAS substance or for another substance. And that scope is going to be limited to TSCA. So even if EPA were to take a risk management action for a particular chemical substance, that preemptive effect is going to be limited to the uses that are covered by TSCA. So it wouldn't cover uses for FDA uses, that are covered as the exclusion from chemical substance of food and food additives, and it also wouldn't apply to example for pesticides. Similarly, this is related to the provisions for the risk evaluation process primarily. So, for example, we had a question about whether this would relate to TSCA CBI provisions. This TSCA CBI provisions are limited to information that EPA receives either in requests and requires under TSCA. It wouldn't impact states' ability to require information on what CBI protections apply there. So our next TSCA 30 for 30 is August 10th. We also have an OSHA 30 for 30 coming up on July 20th. And the next REACH 30 for 30 is also on August 10th. Also, our TSCA Basics course will be this November 3rd in Washington, D.C. Registration for that course is going live later today. So we hope to see many of you in Washington, D.C. in November. So thanks again for joining us today. We appreciate all of your participation, and we'll see you next month. Thanks very much.